We're the Cola Guys. I'm George.
And I'm David.
Today we welcome back Andrew Montgomery. He's with Bell, Carrington, Price, and Gregg.
Yeah.
He's a real estate attorney.
Thanks for having me, guys.
Yeah.
The Cola Guys isn't your average real estate podcast.
Our mission is to give buyers and sellers the power of knowledge through their real estate transactions.
We do this by helping first-time homebuyers realize that there are more expenses that come with owning a home than just the loan.
We also understand there are many times move-up buyers and sellers have forgotten the process because it's been so long since their last real estate transaction.
We make the downsizing easy.
Once you get into the habit of working with us, the process becomes so smooth you won't mind to move.
We are also excited to share with you what all the Midlands has to offer. This episode is brought to you by Dick Dyer Mercedes-Benz, the first Mercedes-Benz in South Carolina.
Welcome back. We appreciate you joining us again on this show. Originally, you came in here and talked to us about the whole home buying, home closing process, and really informative show, and appreciate it. But you know, there a lot of times we help people buy homes, but then sometimes, you know, we help people just buy land.
Right.
And there seem to be a lot of other issues. Even just, you know, you would think it would be, I'm buying a piece of land, but it gets more complicated than that, sometimes even than buying a house. And so that's what we want to talk today, because, you know, people sometimes they want to build their own thing. We were just with some clients not too long ago and talking with them about, well, we want to build, but we want to buy the land first. And we're like, well, you know, there are things we need to talk about. So let's dive into that.
Yep.
Tell us a little bit about yourself first, just to remind our audience who you are and
Sure.
and what you do.
I'm Andrew Montgomery. I'm a real estate attorney at Bell, Carrington, Price, and Gregg. I have offices here in Columbia and Lexington. The majority of my practice, 95% plus, I'd say, is residential transactions, working with folks buying and selling their homes. You know, our firm has offices throughout the Carolinas. We have transactional attorneys, commercial and residential, litigation attorneys, eminent domain attorneys. So a variety of practices, litigation. So that's kind of a little bit about me in a nutshell. Yeah.
Very good.
So what's the difference in your perspective when a client comes to you about purchasing land instead of just purchasing a home?
Yeah. Well, and we talked about last time I was on with you guys, kind of the attorney in South Carolina is required to supervise the real estate transaction, and one of the starting element of that is the abstract of the title, examination of the history of the property, seeing what things involved there, and from that end, you know, it's similar, because that's where it starts for me. It starts at researching the history of the property, seeing, you know, are there people's interests that haven't been accounted for in the chain of title? Are there liens out there? Are there, you know, things that could be an issue? Are there easements, restrictions of record that could affect the property? So from that perspective, it's similar. It's the same underlying concept, but then it's kind of, you know, you guys and the attorney, you know, you're counseling your clients. You want to see what it is they want to do with the property, and, you know, kind of advise from that perspective. And if they want to build a house, you know, some of those things are kind of outside the closing, but you want to work with them on the front end, see what they're looking to do. I think it's, you know, we'll point out things that say, like, hey, there's restrictions, there's easements here, and also advise, you know, this is something you want to talk with your county, talk with the town about, see like what their restrictions, their requirements are. Have a good builder, just like I think we talked about in the past, you know, a good team of your agent, your lender, your attorney. You know, if you're building on the property, have a good builder, and just kind of advising there's going to be some things, you know, after the closing that we're going to have to work on from that end.
Yeah, so, you know, here in South Carolina, you know, we've got several nice larger cities: Charleston,
Yep.
Columbia, Greenville, Rock Hill, you know, Myrtle Beach area. But you know, there's a lot of rural areas in South Carolina still. And you know, even where we are here in outside of Irmo, it doesn't take long to get out in the country where families still own large tracts of
Right.
land. And so, what are some of the things sometimes that you run into when, you know, somebody puts 40 acres up for sale, right? And you know, and I as a buyer maybe want to go buy that 40 acres from George, but George maybe has a cell phone tower that's in the middle of
Right,
it,
right.
or I noticed like the trees look awfully young on this property. Why is that? So what are things like that we need to consider when other things like that are in place on the property?
Right. Well, and like when you're looking at the title history of the property, sometimes it's pretty clear where things are. Like if you're in a subdivision,
Yeah.
that subdivision's been established for 30 years. The house has been there on that lot. There's neighborhood plats have been done, potentially surveys of the individual property. The further out you go and you have larger tracts of land, you want to
Yeah.
make sure, for one, it's kind of clear what you're buying. George's family may have owned this land for 60 years, and the property may be described as, we begin at the tree, and we go to the creek, and then we go from there, and everybody kind of understands, and the county has a general like GIS parcel map of
Yeah.
what we think this property is from the information we have. But it might be beneficial to get a survey
Yeah.
to do things like that. Your use of the property, like you talked about. If you're looking at it from a timber perspective, you want to evaluate that, see what is the established history there. The cell phone tower that you mentioned, it's something, you might want to talk with an appraiser about, seeing, there's different like studies out there think
Yeah.
that, say, cell phone tower might have an impact on value of 5, 6, 7%. So talk with an appraiser, see about those things. Just like with a home, you're studying the, what are the easements and restrictions and covenants on this property? Are there, what goes with that cell phone tower? How far
Yeah.
are their rights? Where are the lines underneath and above ground? Things like that. Juris doctor, not a medical doctor. I know there's stuff about electromagnetic waves, but I don't know. I don't know where to begin on that part. But it's just seeing if there are things like some land might be restricted in terms of use, either with the county or maybe George's family said this is only to be used for this particular use. So that's things you want to study in the property records.
Okay, so go ahead.
Talking about land use, you had mentioned like what you're able to do with it. How hard is it then for someone to get the land zoned commercial instead of residential, if that's how it already was?
Right. So, and it's something too. That's where you're also going to want to talk with your local governments. Find out. You call the county and say, one, is this a zoning question for the county? And they may say, actually, you need to go to the town. And then when you call the town, they tell you to go back to the county. But no, but it's working with those, figure out who has the zoning ordinances in effect. I was looking at the Lexington County zoning map the other day, and they have a zoning ordinance and a chart that shows the district uses, shows street classification. So you're trying to see there what are permissible uses for the property. If you're looking at building on land, things like that, you'll submit a application, a permit. They have a planning review meeting process, and my understanding, like on the county level, is a lot of this may be done by like email these days. So you submit your site plan, and then they evaluate that. And the good thing is, though, that you're getting the feedback from various like community organizations or community departments, the land development, landscaping, building, zoning, Department of Transportation. You might get consolidated feedback in like a report that they're going to send you, and you can evaluate from there, see if you need to address any things. You might have to reach out to some of those groups if they haven't weighed in on that planning review submission. And then once you've met those kind of comments, then filling out your application to kind of get it through there. So it can be a little bit of a process, but like the county and town, they're very familiar with these things too. So a lot of that's going to be working not just with your attorney, but working with like the local government and figuring out what can we do, and then if we need to apply to change things, is that possible, and how does that process work?
Yeah, so I want to back up just a little bit, because you were talking about the boundaries of a property and a survey, and you know, I've seen old surveys, you know, where they talk about the rock and the boulder and the tree and that kind of thing. So what's a good rule of thumb for somebody, you know, buying a big piece of property to get a new survey? How, you know, if I've got one and it's 30 years old and nothing's really changed, should I still update it, or should I rely on the 30-year-old survey?
You know, it kind of can be a case by case, you know, evaluation.
Yeah.
Kind of up to you know your personal preference. If things were surveyed well, and you know, maybe you can also study, you know, neighboring properties and see if there's any like discrepancies, any things that might be an issue. You know, I think it's on attractive land, probably always beneficial to get a survey.
Okay.
You know, on a neighborhood lot, you know, if it's like we talked about, it's been an existing house on this block for, you know, 30 plus years. You know, sometimes on that closing schedule that we often work on as attorneys and agents of 30 days or less, you know, a survey is going to take several weeks, and surveyors may be backed up. It may take a little bit longer. So at that point, you're kind of evaluating, you know, where do I want to be on my closing timeline versus taking that risk. I see that the property was platted and surveyed, you know, just 10 years ago. The house hasn't moved. But with a larger tract of land, you know, be beneficial to get one. You're going to often get a title insurance policy. If you're doing a loan to finance, your lender's going to require you to get a policy. A title policy will take exception to things that might be shown on a survey. So you're kind of putting yourself at a little bit of risk there in terms of coverage. If you don't elect to get a survey, then there's, you know, a general exception of things that might have been revealed from that.
Okay. Very good.
So theoretically, if I were a landowner and I posted a no trespassing sign, does that do anything to actually stop people from trespassing? And if I have the sign posted, am I able to enforce it, or do I need to come to an attorney in order to get a no trespassing
Well,
action?
I think anytime that you have somebody kind of encroaching on your land, you know, I'd want to document that, you know, some form of objection to that. The more documentation that, you know, you haven't just acquiesced to their being on the property. You know, things like adverse possession can get into, you know, 10 years of you know, open, notorious use and things like that. But I think anytime if you came to the realization that somebody might be encroaching on your land, you know, it'd be beneficial to talk to an attorney, document, you know, what you need to do to, you know, make it clear that you don't agree to that.
Don't shoot first.
Well,
play nice.
I'm not that type of attorney, so you know, if you take the law in your own hands, so no, I didn't get
no,
it myself.
we're just kidding. So, you've talked a little bit about easements. And people, I think, sometimes get confused between like what is an easement and what is a deed.
Sure.
So, you know, if I own, you know, if I'm buying this theoretical 40 acres from George, and there's an easement right down through the middle of it, right, for somebody's, you know, that lives on the other side of the property. How is that? What does, you know, what's the difference between that easement and, you know, the deed I have of the property?
So, you know, the deed is the possessory ownership interest in the property. The easement, you're kind of granting a non-possessory right that benefits somebody, the easement holder, to go over your property. You know, there's different types of easements. You know, a simple, straightforward might be, you know, I grant George the right to go over my land to get to the public road. And we've recorded a document, and that's like an express easement of what I've done. You might hear terms like easement by implication, easement by necessity, and sometimes things aren't, you know, aren't as clean cut as that, where I specifically recorded a document that said, George, you can go on this path along my property. You know, an example might be, you know, I own 80 acres, and then we split it up, and I give George, you know, 40 acres, and he has a barn on that, and I have a gravel pathway that goes over my lot to get to the road. And the gravel pathway has always been what has been used to get to that barn.
Yeah.
It's kind of the existing use. It's the reasonable necessity to get there. And George might have another way to get to the land and get to his property that technically has some access, but there might be an easement by implication that says, I can go over Andrew's land to use that gravel pathway. That's always been the intent. So the easement by necessity might be a similar situation.
Okay.
I own 80 acres. I'm right off the public road. And then I sell George the back 40 acres. And he's landlocked, meaning he can't get there by any means, of legal access.
Yeah.
So by necessity, he has to go over my property. Now, the best thing, I think, when you're looking at the title search and you see a property that's locked off, that technically you're not seeing where there was easement established, that's where it'd be best practice to work with that before you buy the land. Say George wants to make sure that it's put in writing that Andrew's going to give an easement over. That way you don't have to go into trying to establish, well, everybody knows that we've always used this gravel road to get to the barn, or I know he can't in theory get there, but that's how it happens. So there's several types of easements, and that can be an impact on the property. Things like cable lines and SC&G utility lines. Those are often long-standing, from many places that doesn't have like as practical impact like in a subdivision. But say you're buying this tract of land. I had somebody call me not too long ago and they said, we bought this tract. We're going to build a 7,000 square foot house, and we want to put in a swimming pool.
Yeah.
And now we've come across, where we want to put the pool is there's a utility easement.
Yeah.
And that's reflected in the title work. But from a practical standpoint, they didn't understand the scope of the project they were doing, and as they got to that part of the land, now they're having to look at how do we rearrange things. Do we pay money to help the utility company move the easement, which could be $10,000-$15,000, or do we kind of rearrange what we're downsize our 7,000? It's a good problem to have, but do we downsize our 7,000 to a smaller house? Things like that.
Yeah.
When it comes to surveys, what happens when a new survey conflicts with an old survey, and do easements show up on the surveys?
It can depend on the scope of the survey, what'll show up. Like on a commercial transaction, there might be a higher level of a survey that, they take the title commitment that the attorney's office has prepared. They look to show all the easements and right-of-ways, utilities that are documented of record. They're relying on different things that might be filed with the county, that title commitment that the attorney's prepared, things that might not be in the register of deeds too, that might have some information. They look at previous surveys of the property, kind of put it all together. If you have and you might just have a plat though that just kind of just describes the overall tract, the boundaries to make things clear. And when you come across like a discrepancy, it can be a situation where that's where you work with your neighbor to get things cleared up. You might have to do like a quick claim deed back and forth where you kind of re-clarify, hey, part of this tract is actually George's land, and part's actually David's. We need to kind of convey our interest in our respective land just to make sure that going forward, when George goes to sell this land, that it's clear that he has the ownership interest of everything. So you sometimes see it, what we talked about too, when you rely on those old legal descriptions of the rock and the tree and things, or even just an old plat that was, a little bit less clear than a new plat. And sometimes you'll see lots are redrawn. There might be a change by the developer and things. They say originally the lots were here, we've reshifted things, and you want to make sure going through that when things got shifted over that everybody kind of did those conveyances to make sure that the new lot 1 and the new lot 2 are what they are intended to be.
Gotcha. So
there's statute provisions that talk about if it is for that greater public good.
Yeah.
And the most common example is like the DOT, to build a road, to expand things, needs to, take a portion of the land.
Yeah.
And I'll qualify, I don't practice in eminent domain,
Yeah.
but we do have several attorneys who do, so if you need
Yeah.
somebody, call the good folks at Carrington. But in general, when the DOT they'll have contractors submit their
Yeah.
bids and see who's going to work the project. The contractor will then, they'll work with third-party agents to reach out to the affected homeowners, to the landowners, and go through each of, a project could be 100 homes, and they'll contact each of the homeowners about things. What they'll do is, this is kind of a broad overview, but they will get an appraisal or two. They'll have a value set on the property. The land itself, like, it's going to be very specific. The 0.2 of an acre, that's measured to the T. Then the question comes down to what are the thoughts on the value of the property? I'm the DOT.
Yeah.
I tell you my appraisal says it's worth this. I'm going to offer you this portion of money, and then you say, no, David's land is worth it's worth more than that. And that's kind of where it comes down to, like, on a simplified version. You either reach an agreement, or then an action will be filed, like a condemnation action.
Yeah.
And at that point, the roadway could start. Once the condemnation is filed, if you couldn't reach an agreement before, the condemnation could start for the public good, and then it really just comes down to the question about the value of the property.
Okay.
So that they can begin construction, keep things moving along, and then it just is up to the court system to kind of determine what is the process. And if you can't reach an agreement either independently or with somebody advocating on your behalf before,
Yeah.
you go through that process, and it can be very similar to any other court case. You could have depositions where you're bringing in different appraisers, different parties to weigh in on the matter. It might be a matter that you hear directly before a judge. It might be a matter that goes before a jury. So kind of procedurally could be like any other case at that point. You'll mediate the issues, and then you may have to go to trial. And it's it's something, there are some provisions that allow for those cases to be moved up a little bit in priority.
Yeah.
But it can still be a process that could take a year, take 3 years, and that's why I enjoy the transactional side. No ties, and don't have to deal with a 3-year case. But that's that it can be a little bit of a process.
Okay. Awesome. Well, that's just, you hear people talk about their land being taken, and it's just nice to know
Sure.
that, there is a process in place for that.
Yeah.
Whether the people feel like it's fair or not, and however it works out, at least there is a process in place.
Right.
So, George, do you have any other questions?
I'm good. Thanks so much for joining us today, Andrew.
Thank you guys for having me.
We appreciate you being back and working with us, and so thank you. And I'm sure there's plenty of other legal topics to cover to fill another episode or two with you. So thank you for joining us.
Thanks.